Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase RIC, of the
Internet, buckle in, because today's sovereign citizen decided to enter court like he's casting a spell instead of stating his name. This is Eric Martin, or as he calls himself, capital E lowercase R-I of the capital M-A-N family, a living sovereign, one of the people. From fake legal jargon to imaginary higher laws, Eric thinks the judge, the prosecutor, and literally the entire traffic code bow to his personal mythology about traveling, not driving. But when he tries to hijack the hearing with demands, lawsuits, and a self-written constitution only he recognizes, the judge finally reaches her limit. And trust me, the moment she shuts down his fantasy world is the moment this whole case explodes.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase RIC, of the capital M, lowercase ARTIN family, a living sovereign, one of the people.
Assistant Public Defender Davi Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day, and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I looked at the video, and I also filed some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all the motions that you brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not preparing?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't style it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffy.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to the third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence I was
Mr.
doing.
Martin, you're gonna need to speak up if you want to have a transcript of this because it's not.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
You're kind of a little closer now. How's that?
Is that any better?
How's that?
How's that one clear? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true because, as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now, I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. So that's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. Well, no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since Mr. I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court.
Y'all, this is where the wheels officially come off. Eric is now claiming, again, that state law is unconstitutional. The court has no jurisdiction, and he doesn't need a license because the Supreme Court supposedly said so. Classic sovereign move, cite imaginary cases, misquote real ones, and ignore every actual ruling. Let's break it down simply. His right to travel argument, completely debunked for decades. His not-for-profit, so no license theory, never existed in real law. His UCC Article 6 Supremacy Clause overrides traffic codes. That's sovereign word salad. UCC doesn't apply to criminal charges, and the Supremacy Clause doesn't magically remove licensing requirements. And the irony? The prosecutor even notes he incriminated himself on the record multiple times. Someone explain this. How does a man who talks this much about higher law understand none of the actual law?
It has no jurisdiction as indicated, as I indicated in my demand under the U.S. Constitution. Only the
Sir,
U.S.
sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the
So-
May jury selection, Your Honor, or?
No, it's not. We're gonna do a July 25th July 25th final settlement conference.
Okay.
And August 9th. Jury
Right.
selection.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery. All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. So it was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm gonna
Okay.
tell him in just 1 second.
Mhm.
All right.
Yeah.
The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on. July 25th, 24, right? 8 p.m. a.m. you said, right?
It's at 11 a.m., sir.
You know, I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or did you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the what's the other date now? August. What else?
August 9th
Okay,
at 8:30.
8:30. And what's that considered? What's that called there?
Jury selection, sir.
Now, which is in person here now? The 7/25/24. Is that something I have to be there in person for? I'm being
For the fourth
threatened to go
time,
up there.
Mr. Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
So we got it. So you're saying a whole bunch of wonders, you know.
All right, we're
Yeah,
done today. Have a good day, Mr. Martin. Bye-bye.
Team. By the end of this hearing, Eric has burned through sovereign talking points like a speed run. Jurisdiction denial, right to travel, Article 6, federal lawsuits, threats of constitutional collapse, and even, out of nowhere, a 13th Amendment slavery claim because he has to attend court. But here's the key takeaway. None of it worked. Not one motion, not one demand, not one invented legal theory. The judge calmly reminds him that she already ruled on his motions weeks ago. He just refused to file the orders because he didn't like the outcome. And when he tries to reopen every argument, she shuts it all down and moves the case straight to jury selection. This is the reality of sovereign tactics. They don't delay the process. They don't erase charges. They don't create immunity. They only stack frustration, waste time, and destroy credibility in front of the court. And with Eric repeating the same debunked claims over and over, he walked himself directly into a trial that could have been resolved months earlier. If you want more breakdowns of courtroom meltdowns, sovereign clownery, and legal chaos, hit that like button, drop a comment, and subscribe. And don't forget to turn on the bell. You won't want to miss what happens at that jury trial.